Okay, so I think we'll get going. It's my great pleasure to be chairing this panel on governance provisions in this conference today. First of all, I'm going to introduce our three speakers in the panel. Our first speaker is Joris Larik, who is going to speak to the topic of supervision and dispute resolution. Joris is Assistant Professor of Comparative EU and International Law and a member of Young Academy Leiden. His research focuses on EU external relations law and global governance. And Dr. Larik is the author and editor of several books, including with Oxford and Cambridge University Press. Then our second speaker is Robert Howse, who will talk to the topic of safeguards. Robert is the Lloyd C. Nelson Professor of International Law at NYU School of Law. His teaching and research focuses on international economic law and legal and political philosophy. And he's co-founder and co-convener of the New York City Area Working Group on International Economic Law and serves on the American Bar Association Working Group on Investment Treaties. And our third speaker in the panel is Brendan O'Leary, who will speak to the topic of consent. Brendan is an Irish, European Union and US citizen, and since 2003 is the Lauder Professor of Political Science at the University of Pennsylvania. He's the author, co-author and co-editor of 28 books and collections, and the author or co-author of hundreds of articles or chapters. His latest production is a 3-volume study called A Treatise on Northern Ireland, which is published by Oxford University Press. So each of our speakers will have 15 minutes each, and they will speak consecutively, so one after the other. And then we'll open it up afterwards for questions and answers and some discussion. So please feel free to use the chat feature for your questions or any comments that you might have. And we might also be able to use the raise hands feature afterwards as well. So without any delay, I will hand over to our first speaker, Joris Larik.
Thanks very much, Sharon. I hope everyone can hear me. And then let me start off by congratulating Federico and the whole team at DCU for putting up this amazing conference on the Northern Ireland Protocol, which of course keeps us busy. So I'll dive right in if that's okay. Let me share my screen, my PowerPoint. And I think some of it I'll be able to go through rather quickly because you've heard already quite a lot about the protocol. So I think everyone will have understood by now that yes, Northern Ireland is still part of the single market for goods. A lot of EU law still applies to Ireland. So what I want to talk about, what I focus on in the presentation, also in the working paper that you can find on this already on the Brexit Institute's website, is the governance and dispute settlement procedures, mechanisms that apply to Northern Ireland due to the protocol. And maybe first off, yes, there's Article 16, and we'll get to Article 16 in Rob House's presentation, but there's also much more to that than maybe is covered by the media at the current stage. Also, after Bertie Ahern's comments from yesterday, I thought let's be kind to Northern Ireland, make a bit of an advertisement. It's certainly, I'm sure it's a nice place to visit. But yeah, if I had to design a slogan that expresses its current situation, it would be something like this here: have your cake and eat it between a rock and a hard place. So it's really this place that was supposed to, it was sold, I think, also to the people of Northern Ireland that would benefit from this the best of two worlds, and right now in practice we see actually that they're very much torn in between the EU and the UK, and that's also very much reflected in the governance and dispute settlement procedures, which right now govern a lot of what's going on in Northern Ireland. So I'll focus on these main points that you can see here in the overview. My main I want to spend most time on really the supervision and dispute resolution mechanisms and also bring in some theoretical perspectives. Okay, so it has those mechanisms have the questionable honor in the whole wider architecture of the post-Brexit arrangements of having been activated first already in October 2020, although you could say that was still a transition period, but also then in March 2021. So this is something that at least the European Commission doesn't shy from at least taking the first steps on. And what all of this reveals, both the text of the protocol, but also the fledgling but interesting practice, is what I call the Janus-faced character of the Northern Ireland Protocol. It really has these almost contradictory natures in it. It is public international law. It's part of as an integral part of the Withdrawal Agreement, an international agreement, and part of then also this wider structure, which I have come to call post-Brexit law. See a little overview here, because these two agreements are also interlinked, and there's a very important link between the Northern Ireland Protocol and the Trade and Cooperation Agreement when it comes to enforcement that I will focus on later. At the same time, though, so on the one hand, it's classic public international law. On the other hand, at the other extreme end of the spectrum, you could say, it is the Northern Ireland Protocol in particular is an enduring holdout of EU law and EU institutions continuing to operate with regard to Northern Ireland as if Northern Ireland was still in the EU. And that's all reflected in those provisions. And my thesis, well, not a very optimistic one, is that given the way these structures have been set up, seeing the way we see them being used in this early stage, and also what we can see of the way the EU and the UK, or at least their governments and institutions, perceive this, I think we have a fundamental mismatch which really risks exacerbating rather than exacerbating disputes, not just regarding Northern Ireland, but EU-UK relations overall, rather than mending them, contributing to these stable and friendly relations that the post-Brexit agreements promised us. I don't need to spend too much time here. I think that's pretty clear by now that all of this is very controversial, has been in the negotiations, still is. It's just interesting to note that looking at the dispute settlement provisions, it brings really together arguably the two most controversial topics of this whole saga: the status of Northern Ireland, the famous Trilemma, as Laura Kilman calls it, and the jurisdiction of the CJEU, the foreign judges, the court that's oppressing the UK from the Brexiteers' point of view. So all of this comes together here in this topic. We've gone through different models in the negotiations where always the role of the CJEU came up, as different designs were put forward to this. I won't go into any more detail here. We have a whole presentation on democratic consent as well, and focus on what we have today. But it is a bit of a convoluted and problematic compromise of these extreme positions of both the EU and the UK. So yes, the foreign judges are still there on the one hand, but there's limits, or at least limits that the UK would have wanted to see and still would like to see in changing the protocol. Okay, a few words on institutions and governance. So on the one hand, so again, going to one of the two natures of the protocol, we see distinct intergovernmentalism. It's an integral part of the Withdrawal Agreement. So also the Withdrawal Agreement's governance institutional provisions apply to the Northern Ireland Protocol. That becomes clear if we look at the apex body, the Joint Committee. It's also ultimately responsible for the implementation of the protocol. So decides by mutual consent. There's no majorities there. Here you can see them. It also establishes the infamous list of criteria for goods being not at risk. It has done that, so that's an important task it has. It's actually the only body that takes really binding decisions. So everything I mentioned after this is purely of a consultative nature, only something that makes only bodies that make recommendations. Another important part of what the Joint Committee does, it decides on the applicability of new legislation to Northern Ireland. So if something's not updated, but another piece of legislation that might be relevant here comes up, it decides on that as well. Then we have a number of Northern Ireland Protocol-specific bodies, a specialized committee on the implementation of the protocol, drafts decisions and recommendations, considers proposals from the various North-South bodies. So they still exist or are now in action again, as the colleagues in Ireland will well know. Also human rights related bodies. And then we've also got a joint consultative working group for information sharing. But yeah, all of this, so if you want to take any legally binding decisions, both the EU and the UK have a veto. Nothing happens basically unless you have this, I think what Michael Doyle called it once, continuous sovereign consent as a hallmark of intergovernmentalism. But We have also the other spectrum, end of the spectrum represented in the protocol. That's specifically more the protocol itself, and the continued role of the EU institutions, which we call is really kind of lingering supranationalism. They're still there. They're still literally, according to the protocol, have the powers conferred upon them by union law, still with regard to the provisions that were addressed in the previous panel, the continued participation of Northern Ireland in the EU's common market for goods, which includes also this continued application of quite substantial chunks of EU law specified in the annexes to the protocol. So let me come back to this point of what happens to that legislation. As anybody, any student of EU law will know, it's not very static. It's not something you ratify and then it doesn't get changed in decades. It's something that's very detailed and that's continuously evolving. So how does the protocol deal with that? So changes to the legislation, to the pieces that are mentioned in the annexes, they apply directly to the UK. So there's no, with regard to Northern Ireland, so there's no UK approval, for instance, in the Joint Committee, necessary to make those changes effective. So this is really dynamic alignment, and it's really, I think, one of the starkest examples of I think what this cartoon tries to express. I think it does that quite well. The UK being a rule taker, so not having any particular veto powers here. So basically, whatever the EU decides in its legislative procedures will apply to the UK. But if it falls outside of the pieces of legislation that are mentioned in the annexes, the Joint Committee comes back in. So then we need the UK's approval. But even here, there's a built-in disincentive to object to new pieces of EU legislation being applied to Northern Ireland, because there's also here the possibility for the EU to take appropriate remedial measures, whatever that means. So I'm very open also to further suggestions on what is meant by it. Here is this remedial measures as an anti-dumping kind of duties, but this is also quite a different context from that. It's about update new legislation that the EU thinks should apply to Northern Ireland, but the UK doesn't want it to apply. So what kind of response would the EU then mount based on this provision? Okay, so far to the on the institutions. Now to the main event, so to speak, the supervision and dispute settlement provisions. So it's not hypothetical anymore to say everything will get politically resolved. It'll all be fine. It's all a matter of diplomacy. No, we have seen disputes already escalate quite a bit. We have seen first steps being taken in the activation of the dispute settlement procedure. So what are they, and how do they reveal this two-faced nature of the protocol? So yeah, the UK government is responsible for the implementation of EU law made applicable to by the protocol. As we know, it's the Northern Ireland remains part of the UK, and the UK's internal market as a kind of neologism, as Catherine Bernard pointed out. But there's also here a long shadow of the EU institutions. So there is an on-the-ground role foreseen for EU officials. They're supposed to be facilitated by the UK government. But even this didn't work out as well. Even this got politicized and led to an early dispute when the EU floated the idea of having an office opened in Belfast. So I don't know if there's any Lord of the Rings fans out there, but this is definitely not what it was supposed to look like, but how it was, I think, depicted in the media in the UK as some kind of surveillance authority that would then run and maybe oppress Northern Ireland. So that was, for political reasons, very much rejected. I think the EU has given up that plan in the meantime, but it would have been useful in some regards to have something present there, given those duties and roles that are foreseen for the EU institutions on the ground. Even more importantly, even more controversially, is of course the continued jurisdiction of the CJEU. That's something the UK government wants to get rid of, and has been pushing for, in particular Robert Frost in recent times. But yeah, the CJEU continues to have the power to issue preliminary rulings on questions regarding to the protocol. This is explicitly mentioned in the protocol itself. This is quite an interesting formulation. So the EU institutions, which would include the CJEU, keep the same powers they have under EU law. And then it says, in particular, preliminary references jurisdiction continues to apply. It's a bit strange because okay, we know that definitely applies. Does that mean then, a contrario, that infringement proceedings wouldn't apply anymore? But I think looking at the language and the structure, and then also how other people like Jan Wouters and Steve Pearce have interpreted this, and I would agree with them. No, I mean, if this is mentioned as something in particular, but also other powers, important ones such as infringement proceedings, should still apply. The Commission certainly thinks so, because it has already started infringement proceedings at one point against the UK. In which then the UK can participate as a member state, but that's pretty straightforward. Otherwise, that would be very unfair. So that's again very supranational, very much as if Northern Ireland or the UK with regard to Northern Ireland was still a member state. But then we also have the dispute settlement procedures under the Withdrawal Agreement, which are a lot more intergovernmental, but not as intergovernmental as what we find under the TCA. So there's this interesting provision saying here in the protocol regarding the protocol's dispute settlement mechanisms, the withdrawal agreements mechanisms will also apply without prejudice to the provisions of this protocol. So that led to some reflections on my side also in the working paper. Yeah, do you have to choose one then, or what does that exactly mean? Do you have to sequence them, or once you pick one, you have to stick with it as a kind of fork in the road provision? So I'd say the protocol itself and the withdrawal agreement isn't entirely clear on this. The Commission's approach certainly is that both should be possible at the same time, so that you can pursue these two routes in parallel. And yeah, one important comeback that the CJEU has also in the arbitration procedure under the withdrawal agreement that it doesn't have under the TCA is that it will be, it should provide rulings on questions and concepts of EU law, so it's pretty broadly defined, upon the request of the arbitral tribunal. So it's not something that any of the parties can really force, but something the tribunal should do. Okay. So yeah, on the relationship between the two, I would say, yeah, I would just say the protocol isn't very clear on that. The Commission certainly thinks you can do all at the same time. If you look at Vice President Šefčovič's letter from March 2021, how you have basically both being started at the same time, a formal notice, a letter of notice, which is the first step in infringement proceedings under EU law. But there was also a thing that the press release of the Commission calls a political letter to enter into consultations in the joint committee, which would be the first step towards arbitration. If that doesn't work, then you can go to arbitration. So it seems that they just pursued this really two-pronged approach at the same time. Another thing I was wondering about was then, is there any separation of what kind of violations you can have adjudicated in these different routes? I think the only thing we know is that the CJEU has a quite limited jurisdiction in the sense that it can't start ruling on violations outside of the remit of the protocol, so Articles 5 and 7 to 10. But on the other side, what can these arbitral tribunals actually rule upon? Are they then excluded from ruling on violations of the protocol as such, or on violations of EU law made applicable through the protocol to Northern Ireland? That's on the language of the protocol itself. It's not entirely clear. At least from the Commission's point of view, they seem to think all of that goes. So, and there's what I call the hinge of Article 5 in the withdrawal agreement, had the good faith provision, where they say in the letter that the UK's failure to fully implement EU law made applicable through the protocol is in itself a violation also of the good faith obligation in Article 5 of the withdrawal agreement. And in a way, I think with that construction, you really open the door that I would say almost any violation of the protocol, including EU law made applicable, would also, you could construe that as a good faith violation. And let's not forget, the protocol is an integral part of the withdrawal agreement. So violating the protocol, you can also say, is violating part of the withdrawal agreement over which the arbitral tribunals have a jurisdiction. That's what the Commission says. It seems not completely not plausible under the language of the protocol, but still, it'd be interesting to see if the CJEU or tribunal has something to say about this, or this kind of parallel approach being challenged perhaps by the UK in the future.
Joris, apologies for interrupting you there, but we're over the 15 minutes. So okay. Would it be possible to quickly wrap up? Absolutely, yeah. So there's maybe two more things I want to mention. One is the link to the Trade and Cooperation Agreement. So maybe also
what the UK might be careful what it wishes for if you want to really get rid of the CJEU altogether and go straight for arbitration, because here's really where the EU can bring its full market power to bear, because there's this, I think, very central provision in the TCA which says, well, you can also ultimately, in cases of persistent non-compliance, you can ultimately suspend obligations under other agreements, but we all know what that means. That's primarily the TCA. So that could also lead then to basically pan-European trade wars on behalf of the protocol. And yeah, here the EU really has decades of experience, target practice with carousel sanctions, targeting iconic and politically sensitive products in the US. So you could see also here's some suggestions visualized with regard to the UK. There's some restrictions that apply to that. So it's not a total free-for-all. It needs to be proportionate, but again, that could would then be for the UK to be challenged. So the main point here, and the details all in the working paper, is what we see. I think this has been largely designed by the EU, pushed through by the EU. It's also what the UK government is criticizing, and it really relies very much on driving up the economic costs of non-compliance, as well as the reputational costs. How you're being shamed by having your behavior being declared illegal by the CJEU, by an arbitral tribunal, maybe having some sanctions being applied then. So that speaks to a particular rationalist approach to compliance. If it works against the UK, I'm not so sure in the specific post-Brexit context, because what we can see from the UK government is at least an ostensible sense of or an approach showing the protocol is fundamentally illegitimate. The UK was somehow tricked or forced into it. I mean, you can agree with this or not, but that's how they present it. And it can really play also to its political advantage, or to the government's political advantage at home. That really vindicates, I think, a lot of the Brexiteers' claims that the EU is punitive, is legalistic. It tries to punish the UK here, and the UK is kind of standing up in this in a case that's construed as kind of some noble resistance. So in a way, what this kind of toolbox the EU has created here to enforce compliance might actually be working in quite counterproductive ways. That's basically.
I'm sorry, I'm going to have to ask you to finish up, because we're really over the 15 minutes.
And that's it. Yeah, no, I'll leave it at that. So a conflict-laden start, a rocky road ahead, but also certainly lots of interesting questions for research and practice in the coming months and years. Thanks very much.
Thank you very much, Joris, for that very interesting presentation. I can see that there are some questions coming in on the chat, which is great. Because we're taking all the speakers together and we're going to do the Q&A at the end, could I ask you, please, if you have a specific question for one of the speakers, that you might just put their name in front of the chat so we know who that's for, or if it's for anybody, we can also direct it to anyone on the panel today. So thank you very much for that. I'm sorry about interrupting you, Joris. 15 minutes is a very small piece of time, I understand. So we'll move directly to Robert for our next presentation.
Okay, thank you very much. It's a pleasure to be here. Before we plunge into the text of Article 16, I thought I would just, based on the introduction to the paper that you all have, set up what I consider to be, or what I call to be, the trilemma to which the protocol in general is addressed. And this really reflects the priority of making sure that, or attempting to make sure that, the arrangements for Brexit do not destabilize the peace agreement and the peace process between Northern Ireland and Ireland, and of course Great Britain. And so the fact is that one part of that, essential part of that process and understanding has been that there would not be a hard land border between Northern Ireland and Ireland. And so the trilemma is the following, that one has to avoid that hard border one needs to be able to retain the EU's right to enforce its laws and regulations with respect to goods that risk entering into the stream of commerce within the EU from the island of Ireland. And then an objective that's very important to the relationship between Great Britain and the North, which is to ensure unrestricted trade between Northern Ireland and Great Britain. So how can you have all these three things at the same time? There's no obvious solution except the one that was, as a political choice, rejected by the UK in the Trade and Cooperation Agreement, which was to maintain regulatory harmonization for purposes of trade. If you don't have regulatory harmonization, then there has to be some way of ensuring the compliance of goods that land on the island of Ireland, and if you're not going to have a hard land border, you have to do that in some other way. And so the protocol provides a framework of doing it in some other way. But of course, there's no solution to this trilemma apart from moving towards what would seem to be very sensible, which is back towards some kind of regulatory harmonization that provides a perfect solution. There's always going to be some cost in terms of customs administrations and procedures and border bottlenecks, because you have to have some way in which the EU can reasonably ensure the compliance of these goods with its regulations before they essentially enter a stream of commerce that leads into the EU market. And so the protocol is one way of achieving that, and I think it's predictable that it wouldn't be perfect. That in some some interests would regard the costs and burdens of this solution as problematic. But without harmonization, there is no kind of ideal solution against which the arrangements in the protocol could be compared and found in principle wanting. Apart, perhaps, if one assumes technological innovation, it's possible in an ideal world, a futuristic world, perhaps to have a simply electronic border, in the sense that regulatory compliance is done in such a way that goods are not actually stopped or interrupted or delayed in terms of their movement, across the Irish Sea. So one could hope for a technological future. One can hope for a future of regulatory harmonization, but given the realities we have today, I mean, there's no set of solutions, to my understanding as a trade lawyer, to this trilemma that will not have certain costs and burdens on various interests or parties. So then, I think that's the frame for looking at Article 16, and because there's been so much political rhetoric surrounding Article 16, almost all of which never cites the text of the article, I thought that the focus of my presentation could usefully be the text, and that's what we're going to try and fathom in the next 10 minutes or so. So I'm now going to turn to the slides. Okay, so let's start with the actual text of Article 16.1, which is what all the talk is about in terms of whether the UK or Johnson, the Prime Minister, will quote unquote trigger Article 16.1. So the trigger image is that Article 16.1 is a weapon. And so the question is, what kind of ammunition is in the weapon. And this is, a lot. There's been a lot of talk of triggering a weapon, but without much discussion of what you're shooting out of the weapon or whether it could shoot at all. So if the application of this protocol leads to serious economic, societal, or environmental difficulties that are liable to persist, or diversion of trade, the Union or the UK may take quote unquote appropriate safeguard measures. These have to be restricted with regard to scope and duration to what is quote unquote strictly necessary in order to remedy the situation. The priority shall be given to such measures as will least disturb the functioning of this protocol. And so then we have 16.2 and 3. And 16.2 enables the other party to respond to a safeguard measure by taking proportionate rebalancing measures that are strictly necessary to remedy the imbalance. The priority shall be given to measures as will least disturb the functioning of this protocol. And then both the safeguard and rebalancing measures are subject to procedures in Annex 7. And basically, this involves the Joint Committee reviewing and facilitating or attempting to facilitate consultations to finding a quote unquote commonly acceptable solution. If no such solution is found within a month, then of the notice that a safeguard measure is going to be taken, then the safeguard measure can be imposed, and of course, the responsive measures of the other party, are also going to be permissible. Then there's a requirement, if you look at 5 here, of ongoing review of safeguard measures, quote unquote, with a view to their abolition before the date of expiry. And that just emphasizes the drafters' clear intent that these would be very temporary, measures, and one always had to be re-examining whether the necessity that brought them into being is one that continues. So one of the most striking features to me as a public international lawyer is that Article 16.1 does not create on its face any explicit right to violate, to deviate from, or to derogate from the protocol. As an international lawyer and international trade lawyer, I'm familiar with many clauses in different kinds of international agreements that actually have that functionality, that they permit, under certain exceptional circumstances, a party not to perform some or all of its obligations of the treaty. And so let's look at some examples of these. If you look at the International Covenant of Civil Political Rights, it refers to measures derogating from a party's obligations. The same language of derogating from obligations is in the American Convention on Human Rights, and again in the European Convention, the necessity or emergency clause refers to taking measures derogating from obligations. And so when we turn back to the text of Article 16, we don't see any language of that kind. There are also in other agreements, so this is more typical of the economic agreements, what I call non-preclusion clauses. So if you take a typical example of a bilateral investment treaty, I picked the US-Argentina treaty because there's litigation on the meaning of the emergency clause in that treaty. It refers to this treaty shall not preclude. In other words, the obligations in the treaty of that particular party shall be suspended or not applied to the extent that it needs to take measures here necessary for the maintenance of public order or national or international security. Same with the GATT, the main agreement in the World Trade Organization on trade in goods. Nothing in this agreement shall be construed to prevent. Clearly, the idea here is that a member may, and it's called general exceptions, this provision, but a member may take measures that would otherwise, apart from the situation of necessity or other special situation indicated in Article 20, be considered violations or of its obligations. So this is another way of formulating the idea that a provision allows a deviation from legal obligations. So again, if we go back to the text of 16.1, there's no language in it that clearly states that it permits deviation from obligations. So in the paper, if you have a chance to read it, I offer a different interpretation of 16.1, which is that it's really intended to deal with situations where one of the parties thinks they need to take measures that, well, while not formal deviations from the agreement, would allow the possibility of considering that because the measure, although not a formal violation, nevertheless has resulted in some disruption of the protocol, that it's almost like bad faith, or that, and so if 16.1 is complied with, then there's a sense of the permissibility of taking a non-violation measure, and then the responsive measures, again, because the original safeguard is not a formal or technical violation of any legal provision of the protocol, would also be of a character that would not itself suspend the law in the protocol, but again, if it were not taken in response to an action that disturbs the functioning of the protocol, might itself be considered a form of bad faith. So I think that's the most plausible interpretation, in the sense that there's no language in 16.1 that actually is permissive or authorizing of any suspension or non-performance of the legal obligations in the protocol. Another way of interpreting the absence of language about derogation or non-preclusion would be that really Article 16 is self-evidently in some sense about that, because it deploys the notion of necessity and therefore incorporates with whatever changes might be involved in the specific language in 16, the notion of necessity in general or customary international law. And this has now been codified in the International Law Commission articles on state responsibility, and refers to refers to the preclusion of wrongfulness under an international obligation, which can include a treaty, of an act that is the only way for the state to safeguard, there's the word safeguard, an essential interest against a grave and imminent peril. So one might consider that the drafters had in mind that they were incorporating, again, as modified by the actual text of Article 16.1 and 2, this notion of necessity in public international law. And one of the conditions here is that the state must not have contributed to the situation of necessity. I think to the extent that one reads Article 16 as consistent with or cumulative with customary international law is reflected in Article 25, this would be a big problem for the UK in invoking it, because in some sense the entire situation, if we go back to the trilemma with which I began this presentation, almost the entire situation is basically created by a political choice to de-harmonize regulation, or not to engage in a harmonization exercise. And there's no reason why the UK couldn't have done that. I mean, it was just a political decision. In fact, initially, Theresa May's concept, I think, of of post-withdrawal trade relations with the EU would have encompassed the regulatory dimension. In any case, that's another way of looking at Article 16.1 that can, in some sense, deal with or respond to the fact that it doesn't have any explicit non-derogation or non-preclusion language within it. How many minutes do I have left?
-2, I would say.
Oh, okay.
So if you could wrap up, that would be appreciated. Thank you.
Yeah, just a few comments about specific elements in the text. Leads to, clearly the implication is that the serious difficulties of trade diversion must be caused by the operation of the protocol. So if they've been caused by the underlying trilemma, and it's just that the protocol hasn't solved them, that would not justify invoking Article 16.1. Secondly, liable to persist. The difficulties or the trade diversion have to have an ongoing character. And I think this is intended, perhaps, to make sure that Article 16 is not triggered to deal with what would be considered to be predictable transitional or adjustment costs from implementing the protocol, as opposed to some longer term challenge or problem that was kind of unexpected, but which the protocol has given rise to. Unilaterally remedy the situation. In other words, the measure has to be capable of solving the problem unilaterally without changing the behavior of the other party to the agreement. It's not, 16.1 is not a stick to incite or pressure behavior by the other party. And the measure must, again, unilaterally, must be effective on its own without any assumption of cooperation from the other party. So those are some textual features that I think would have to be borne in mind and considered very carefully before the UK made any decision to bring 16.1 into play. And I would just then stress what Joris already said in his presentation, that ultimately, like other provisions of the protocol, the safeguards provision may be subject to the dispute settlement arrangements.
Thank you very much for that, Robert. There was a lot of really rich information there. I'm sure people will like to follow up with you in our Q&A. So I will move directly now to Brendan and ask him if he would like to take the floor and share the screen.
Good afternoon, everybody, and I'd like to express my thanks to Frederico and his colleagues at Dublin City University. My topic is matters of consent. I have some absurd subtitles to match the appropriate absurdity of the predicaments we find ourselves in. My subtitles are Heath Robinson, Ruby Goldberg, and Hans Rudy Geiger meet Aaron Leiphart. I'll explain that mouthful, but it'll be much easier to understand my second subtitle, Three Big Lies Amid Attempted Perfidy Over the Protocol. As it's the afternoon and I'm the last speaker, it's my duty to be more satirical than the international lawyers who preceded me. If we look at the Good Friday Agreement, it now stands in premier position in the international league table of European treaties. It's played 4 times and it's won on all occasions it's been in difficulty. It's performed much better than the Maastricht Treaty. It's performed better than the Versailles Treaty, but that's not difficult as a standard of competition. And now we have the question of whether it will perform as as well as and continue to perform in compliance with the Withdrawal Agreement and the Protocol and the EU-UK Trade and Cooperation Agreement. I'm going to suggest that our difficulties are absolutely grave and serious, that the Good Friday Agreement is insecure, despite the fact that it has been remarkably secured in the language of the Withdrawal Agreement. The term Perfidious Albion is often used by foreigners to describe the behavior of UK foreign policy. The British are usually very upset by it, which is one reason I usually bring it to their attention. The term Perfidious Albion was coined by a Frenchman, the playwright and scholar Marquis Augustin Louis de Chemin. He knew something about perfidy. He served the Jacobins, the Directorate, Napoleon, and the Bourbons in that order. So he definitely knew what he was talking about. The reason we are thinking about Perfidious Albion at the moment is it seems pretty clear that the key leadership around the Johnson administration insincerely entered into the protocol provisions that are annexed to and an integral part of the Withdrawal Agreement. But I want to emphasize that in that agreement, there's no question that the UK commits itself to protect the Good Friday Agreement in all its parts, and that commitment extends to the practical application of the agreement on the island of Ireland and to the totality of relationships set out in the agreement. Let me make three simple points about this agreement. Treaties are very weak substitutes for agreed constitutions, especially if the United Kingdom is a party to that treaty. And that is because Perfidious Albion is a constitutional condition. It's not the result of the English having spectacularly bad manners in international affairs, though that has been the case recently. It's because if you have a system of parliamentary sovereignty, you can't make credible commitments, either, either in treaties, because any parliament can repudiate that treaty, or in domestic constitutional arrangements, because any parliament can revoke the agreements made by its predecessor. So it's actually very difficult to make binding agreements with the United Kingdom as long as it preserves the doctrine of parliamentary sovereignty. And that's among the reasons why our astute commentator, Fintan O'Toole, has correctly described the UK's strategy towards the European Union. He suggested that if it were a personal ad appearing in a magazine, it would read, "Petulant bolter petulant bolter seeks stable lifetime relationship with the ability to leave it." So I want to emphasize here that we are genuinely dealing with insincerity in the making of the protocol and insincerity in its implementation. The people who are responsible for that are Boris Johnson, Lord David Frost, and to a lesser extent, the Secretary of State for Northern Ireland. Lying in the making of the protocol and insincere signing and implementation are forms of public lie. What is the form of the public lie in official discourse? Lord Frost says that the EU is responsible for legal purism. We should reverse that phrase. What is the opposite of legal purism? It's either illegal purism or it's legal impurity. One of those phrases probably accurately describes current British negotiating behavior. We have to ask ourselves, who's seriously intent on sincerity in current arrangements? Or are we rather like Guy Fawkes, dealing with somebody who entered Parliament with sincere intentions to blow it up? That's what Martin Turner suggests in the Irish Times. What I'd like to do is to give you 100% truth without alloyed lies, agendas, or anything else. I want to tell you that the current arrangements of the protocol, when added to the Good Friday Agreement, create a Heath Robinson or Ruby Goldberg construction. Now, what do I mean by that? We all know that Heath Robinson is famous for creating very complex contraptions and complex machinery in order to do what should be very simple. In this case, preserve the Good Friday Agreement and avoid a hard border on the island of Ireland. He was an Englishman. His American counterpart was Rudy Goldberg, who was also famous for designing very complex machinery to do what should be very simple. And when you're confronted by a Rudy Goldberg or a Heath Robinson device, your immediate instinct is to say, couldn't we do this in a more simple fashion? That's, of course, exactly what the cartoonists intend you to think. And we should all know by now, having had this two-day conference, that the protocol is complexity on top of complexity. Formally, I would say, as a political scientist, it's a limited condominium between the UK and the EU for certain functions, on top of an already complex consociational arrangement for Northern Ireland. But at least it's not what some people advocated a few years ago, namely a Rudy Geiger set of arrangements for Northern Ireland. Rudy Geiger is the famous maker of the Alien in the film of the same name. He's known for producing sculptures that complexly fuse the biological and the mechanical. And that, of course, is a very accurate metaphor for describing the alternative arrangements to the protocol, the technological solutions advocated by many Brexiteers and by many Ulster Unionists. Those alternative arrangements were supposed to produce technological miracles, that goods could be checked in all sorts of ways, and VAT assignments could be made magically by electronic allocation and so on. Why were these technological solutions proposed? The answer is they were cover. The big lie was that the Brexiteers were prepared to countenance a hard border, and the DUP actually wanted a hard border across the island of Ireland, but couldn't admit to that possibility. So the technological solutions provided a cover for malevolent intent. That is part of the predicament with which we are currently confronted. So to put matters very simply, the 1998 and 1999 agreements, the Good Friday Agreement and the treaty that incorporates it, are now layered on top by two other very complex treaties, which the international lawyers among you have been carefully detailing the complexities attached to them. And the question that becomes us to address is, these are now the constitutional arrangements for Northern Ireland. They are immensely complex. It takes a long time to explicate them to anybody. We should ask ourselves, what's the life expectancy of this set of constitutional contraptions? According to my political science colleagues, Zachary Elkins et al., the average lifespan of a constitution is 19 years, which is perilously close to the time period since which the Good Friday Agreement was made. Incidentally, that's roughly the time period that Thomas Jefferson recommended as the lifespan of constitutions. So the question before us is one of consent. In the Good Friday Agreement, consociational arrangements were agreed for the internal government of Northern Ireland. These have four features: the principle of parity among the key partners, the principle of proportionality in representation and allocations of expenditure, the principle of cultural autonomy for each party to the consociation in those matters of most profound concern to them, and lastly, the provision of veto rights. And these veto rights, as we'll see, becomes the basis for the third big lie about the protocol. I'll come to that in a moment. Obviously, the Good Friday Agreement is more than the domestic consociational arrangements in the North. It also includes the complex intergovernmental arrangements in the North-South Ministerial Council, the British Irish Council, and the British Irish Intergovernmental Conference, not to mention all the arrangements and commissions attached to the peace process. The veto rights attached to the Good Friday Agreement are systematically misrepresented. There are cross-community consent procedures attached to the Good Friday Agreement, and there is a separate principle, the principle of consent. And the way the third big lie operates around the principle of consent and the protocol is the suggestion that the arrangements in the protocol somehow violate the principle of consent. Bear with me as I'll explain to you why that is not true, why it is a lie, and why intelligent thought should move forward from dealing with this proposition. In the Northern Ireland Assembly, there are cross-community consent procedures which require special majorities for legislation. These can either be passed through the parallel consent procedure, in which a majority of designated nationalists, a majority of designated unionists, and a majority overall concur. The second special procedure is the weighted majority procedure, under which 60% of the members of the Legislative Assembly in Northern Ireland have to concur, and they have to include 40% as a minimum of registered nationalist MLAs and 40% of designated unionists. Those are the cross-community consent procedures. They are legally attached to certain kinds of decision-making, but they can also become attached to fresh decision-making if there is a petition procedure, and under that petition procedure, 30 MLAs have to call for a decision to be voted on by cross-community consent. The trick here is very simple. These cross-community consent procedures do not apply, have never applied to anything resembling non-devolved functions. And all of the functions attached to the protocol, with some perhaps debatable exceptions, are non-devolved functions. Taxation, VAT, the single market regulation, customs. These are not powers that were devolved to Northern Ireland under the Good Friday Agreement or afterwards. The principle of consent, by comparison with the procedures of cross-community consent, refers only to the choice between maintaining the Union of Great Britain and Northern Ireland or voting to have a united Ireland. That principle of consent does not apply to legislation or policy making over what the UK calls Crown powers, otherwise known as accepted and reserved powers. So, very simply, the Good Friday Agreement was not violated in the making of the Withdrawal Agreement and the protocol attached to it, because the relevant powers were not devolved to Northern Ireland under the terms of the Good Friday Agreement. You don't have to take my word for it. The Secretary of State for Northern Ireland, Julian Smith, a much more law-abiding character than his successor, stated the argument quite plainly in the House of Commons in 2019. For the opposite argument to be true, namely the claim that the protocol and the withdrawal agreement violate the Good Friday Agreement, that would mean the European Union's lawyers, the Government of Ireland's lawyers, and all the lawyers of the European Union member states and the United States looking over their shoulder had somehow violated the Good Friday Agreement in order to save it. But that is exactly what the DUP and other members of the unionist community want us to believe at present. It's not true, it's a lie, and it's an unfortunate lie. The phrase is frequently used by politicians that a coach and horses was driven through the Good Friday Agreement by the protocol and the withdrawal agreement. It's not true. The phrase I've tracked down to my friend, Jonathan Powell, a former Labour advisor on Northern Ireland, who I think made a sincere error in this respect, by contrast with some unionists who deliberately deceive people on this matter. In the case of Powell, he wanted to use any argument possible to keep the UK within the European Union or within a soft exit. So for these purposes, any argument related to Northern Ireland became politically convenient, even if not strictly true. By contrast, unionists, particularly those who never signed up to the Good Friday Agreement in the first place, know how the cross-community consent procedures work in the Northern Ireland Assembly, what they were designed for, and their limitations. So their rhetoric should not be taken, I think, with the gravity that they enunciate. So the principle of consent is just a principle for changing sovereignty. It's a vital part of the 1998 agreement. We heard yesterday from Oren Doyle about how it's supposed to operate. the Government of Ireland changed its constitution to respect this principle of consent, but in return accepted that the UK would sincerely and effectively implement a whole array of power sharing measures, none of which provide for a generalized unionist veto. The next question of consent that arises is whether the protocol affects the constitutional status of Northern Ireland. Well, you don't have to take my word for it. According to Justice Colton, in proceedings before a court in Northern Ireland, proceedings taken by leading lights in the unionist community, he ruled decisively that the protocol was compliant with the existing constitutional arrangements in the United Kingdom. He did in passing indicate that the Act of Union of 1800, an act that was brought about and brought about in the early part of the 19th century as a result of a reaction to Irish Revolution, he pointed out that the Act of Union had indeed been modified as a consequence of Parliament exercising its sovereignty. One constitutional statute, namely the Act of Union of 1800, had been superseded by another, namely the Withdrawal Act, which repealed the European Communities Accession Act. So according to UK constitutional doctrine, which unionists are supposed to accept as loyal subjects of Her Majesty, the protocol was validly in place as a result of a constitutional change that did not affect Northern Ireland's status as part of the United Kingdom, though it did affect its trading arrangements. Colton mentioned in passing that the Sewell Convention, a mechanism whereby the Westminster government was supposed to seek the consent of the devolved legislatures on any matter potentially affecting their powers, is merely a convention, even though it's taken statute form. So the Westminster government is within its rights to legislate despite the lack of legislative consent by any of the devolved legislatures. And none of them did indeed give their consent to the withdrawal agreement. But in the Northern Irish case, that's largely because most parties wanted to remain in the European Union. So to conclude, I'm about to conclude. I'm using the word finally, so people should be very relaxed because that should make them happy. I'm coming to a conclusion at about the same time as my peers. What we have now is the invention of a novel doctrine of consent. Northern Ireland is going to be allowed to retrospectively endorse or to continue the protocol. Under Article 18, democratic consent in Northern Ireland is to be sought to the continuation of the protocol. This can happen through majority rule, and it's limited to approving the extension for Articles 5 to 10. It's only for 4 years. This is done not because the protocol affects Northern Ireland's constitutional status, but because if they had allowed for a general veto over the continuation of the protocol by nationalists or unionists, clearly it would have been deployed immediately by unionists and the protocol would have been rejected by the unionist community. So instead, what has been done in an act of cunning statecraft is to give the Northern Ireland Assembly the right to continue the protocol by majority rule, and if it wishes by cross-community consent, to extend it for a further 4 years. Now, what that means practically is that the fate of the protocol will be decided by the others in the Assembly, the Alliance Party or the Greens or any others who are elected in 2022. So my prediction is that if the Northern Ireland Assembly and the Executive survive and function, that's a big if, then the protocol is then modified in practice, unless in the meantime Her Majesty's government has repudiated the protocol or was deemed to have done so by the EU, then it's going to continue to exist and function because the others will vote for it. The second prediction is that if it is functioning, the Northern Ireland Assembly will only vote for a 4-year extension. Unionists will be highly unlikely to give their consent to an 8-year extension. And that will take us to 2028, which will be about time to have a referendum on the possibility of Irish reunification. And I'll leave my remarks on that theme to any questions that people might wish to pose to me. I'm sorry I was constrained to rush in 15 minutes like my peers, but I hope you find what I have to say of minor interest. Thank you.
Thank you very much, Brendan, also for a very, very interesting presentation there. And thank you to all three of the speakers to the panel, which has been really interesting for everybody, I'm sure. We have a couple of questions coming into the chat here. So if you have questions or comments that you would like to pose, please do that. And if it's for a specific speaker, can you please signal who you would like to address the question to. There were questions already put in for Joris Larik's talk. So Audrey McCready has asked, Joris, would all of this complexity and potential conflict be resolved by the reunification of Ireland and Northern Ireland? So if you could answer that, a very complex question quite briefly, that would be great. Thank you.
I think the short answer would be yeah, probably yes, to a very large extent, because yeah, then obviously the Irish Sea border would be the external border of the EU and its customs territory. So obviating really the need for the protocol, as well as you know, that would also be quite quick accession. I think that's something important to, let me just add to that, because if Northern Ireland joined the EU, it would be this kind of GDR scenario that we had with Eastern Germany, so you become automatically part of the EU, not having to go through the Article 49 Copenhagen criteria accession procedure. So that's a lot easier, for instance, than if Scotland or other parts of the UK were to join. Researchers and lawyers don't have to despair, though, because there's still Cyprus and Gibraltar to obsess over, and the respective protocols there, although the dispute settlement arrangements aren't as complex.
Thank you, Joris. There are some other questions there for you, but there's a question come in now for Rob. So I'll ask him this question, and then I'll probably come back to the other questions that were asked for you. So this question for Rob, can you please ask Rob about trade diversion as a justification for invoking Article 16? Since the UK government appears to see this as a potential justification, do they have any grounds for this?
Well, the first observation is that to me, as an international economic law scholar, trade diversion means something very specific, which is what happens when there is a common tariff wall against third countries. And this is not really applicable here. So we have to puzzle out, and not applicable because there is you know, tariff-free trade. We have to puzzle out what trade diversion means in this particular context. But to my mind, the fundamental question, and typically in the political discussions, any change in trade flows, you know, as between the UK, as between Britain and Northern Ireland, or between the UK and the EU, is called trade diversion. So what we would have to ask is, to what extent are trade flows changed as a consequence of the protocol, or to what extent were those changes predictable, you know, in light of Brexit itself and the necessity to try and preserve the Good Friday Agreement. And I don't see a lot of evidence that it's the protocol itself that has created these changes in trade flows, as opposed to the underlying situation to which the protocol is addressed. So on that basis, there wouldn't be a justification for 16.1 measures, it wouldn't be that the protocol has caused the problem. It may not be the best or ideal solution to the problem, but the trade diversion is reflected in the underlying problem and not caused largely or exclusively by the protocol.
Okay, thank you for that answer. I have a question come in for all panelists, so I might direct this first to Brendan. This is from Ian Cooper. He says, here is a counterfactual question for all panelists. What would the situation be in Northern Ireland if the original version of the withdrawal agreement with the all UK backstop had been adopted? So Brendan, would you like to take that first?
Certainly, I think that if Theresa May's proposals had been accepted, the UK would be a rule taker for all EU legislation ad infinitum. I suspect that that would not have survived the first encounter with the electorate, but we may well have avoided having a Boris Johnson government. But it's a very strange counterfactual, because to accept the counterfactual, you have to accept that Theresa May could somehow have got that legislation through the House of Commons. Plainly, she couldn't. There were 3 separate occasions in which that was attempted, and it was the conjunction of the hardline Brexiteers with the support of the Democratic Unionist Party that made that impossible. So I like counterfactuals, but the counterfactuals have to be plausible. In this case, it wouldn't have been one. If I may take the opportunity to respond to the first question that was posed, quite clearly, Irish reunification would dispense with the need for the Rudy Goldberg and Heath Robinson construction that is the protocol. But there is at present not a majority for Irish reunification in the north. So we have to await for that possibility. In the interim, there is a possibility that the protocol might be scrapped. And if that happened, for whatever reason, that I think could seriously endanger the institutions of the Good Friday Agreement and stability in the UK as a whole. But the most interesting counterfactual, if I may simply comment, is whether there will be a Great Britain, because the likelihood of Scotland becoming independent before Ireland reunifies is quite high. And that raises all sorts of interesting questions about how the protocol and other institutions, including the rights for Northerners to preserve British citizenship, would survive the creation of an independent Scotland.
Thank you very much, Brendan. Would Joris or Rob like to speak to the counterfactual question or make any comments based on what Brendan has just said?
Well, I know, Rob, you go first.
No, only that, you know, I think that Brendan has correctly articulated the political, you know, situation that led to the rejection of a solution involving regulatory harmonization. But, you know, that situation itself was created by, you know, the need to follow through on what I would describe as many false promises connected to the campaign for leaving, you know, the EU. And so I don't think that the political environment is one that reflects some, you know, fundamental underlying reality of the impossibility of having a customs union with elements of regulatory harmonization, but, you know, the kind of, you know, rather despicable and disingenuous politics surrounding Brexit. And I note that there have been some recent polling results that suggest that actually that the British public is becoming less satisfied with Brexit, and while returning to the EU and all of its political institutions and mechanisms and political, legal, administrative ones seems, you know, not in the cards. I'm not sure that the political environment could not become favorable, to something that looks more like a customs union with regulatory harmonization, or a process for meaningful regulatory dialogue and reconciliation. But these are political judgments. I'm just an international law guy, so what do I know?
And Joris.
Yeah, the same applies to me. But I mean, with the counterfactual, I think it's an interesting point that Ian brings up here. I'm just looking over my notes. I mean, which one do we actually mean? There's been so many different iterations. At some point, if it's though the UK, there's the May government's counter proposal to the Commission's initial draft for the withdrawal agreement. So UK-wide backstop with a common rule book. So that would not have included, I think, CJU. They didn't want CJU jurisdiction the way we see it now in the protocol, which brings back infringement proceedings that the Commission has already tried has already launched and then paused. It would only have been this referral procedure, questions of EU law, and then involve the CJU to give an authoritative ruling. I think that's a lot less, unless you're totally illogically opposed to any CJU involvement, that's a lot less invasive than infringement proceedings, where they start to fine you and you have to discipline. So I think that would have been actually, that would have, if that had been adopted, that would have been less CJEU than is currently the case, and it would have removed this particular pressure that Northern Ireland is feeling right now. So for businesses, this would actually have been quite nice, because then not that much would have changed, and maybe would have also then driven up the political cost for the UK government to make any more drastic changes thereafter, because you say, okay, this kind of works too, not too much CJEU, not too much extra red tape, and you kind of ease into this more. It's not quite EEA style, but it's a lot closer of a relationship than we have now under the TCA and with the withdrawal agreement and protocol.
Thank you very much for that. So I'm going to come back to Brendan. There's a question from Michelle, but it's followed by a clarification as well. So if you bear with me. So this is a clarification question. Is the novel doctrine of consent that you mentioned specific to Northern Ireland's context? And how does this fit with consociational democracy? So that's the original question. And then the clarification that follows it is majority rule is not atypical. So is the sense of being novel consent in Northern Ireland context, does it undermine the consociational democracy model? So I hope you got all of that, I'm sorry.
I did, thank you.
Okay.
When I said it was novel, I said I should have clarified, I was rushing. It's novel in relationship to Northern Ireland having special consent procedures for functions that have not historically been devolved. And in effect, the EU and the UK had a choice if they were going to involve Northern Ireland in some process of consent. They faced the immediate difficulty that if they allowed the cross-community consent or consociational procedures to apply, then one side or the other would have the veto. If nationalists got the legislation phrased, the consent procedures phrased the way they would have wanted, they would have kept the protocol, even if there was a majority against it in Northern Ireland. By contrast, unionists would have sought to prevent its application and certainly to prevent its renewal if they got the opportunity to have a veto. So those are the practical reasons why I think the EU and the UK resolved on letting this matter be decided by majority rule. So it's not a consociational consent procedure, the Northern Ireland Assembly's consent to the extension of the protocol for 4 years, though they are allowed to exercise it by cross-community consent for 8 years, which would make a lot of sense from the point of view of creating a stable business horizon for planning purposes and so on. So I think the correct answer to the speaker is that there is certainly a tension between the majority consent principle and standard consociational principles, but there is nothing constitutionally improper in relation to either UK law or the Good Friday Agreement in adding this fresh consent procedure. What is politically and interestingly distinctive about it is that it, for the first time, gives the others pivotality. they will be decisive in shaping the fate of the protocol, provided it survives. And that's interesting because I think, in effect, I didn't have time to say this, but if you're going to predict what's going to happen electorally, I think the others and nationalists will jointly have anywhere between 55 and 60% of the MLAs. So the protocol's future is secured if it survives.
Thank you very much for that clarification. I'm going to go back to an earlier question that was put in the chat box here for Joris. It comes from Catherine. How do we overcome the democratic deficit the DUP are facing with the governance rules of the protocol?
Sounds like more like a question for Brendan, to be honest. We're talking about the democratic consent rules, but so I'm also interested in his thoughts on that. I mean, all I'll say is, I mean, as far as I'm concerned, with the withdrawal agreement and the protocol and the TCA for that matter, they have been all democratically approved based on the constitutional requirements in the EU and the UK respectively, that governed by each side's constitutional arrangements. And yeah, then we have the consent procedure being factored in, even specifically with regards to the protocol. So I would even question the premise if there's a democratic deficit here at all. But yes, I'd like to hear Brendan on this.
I agree entirely with you. There is no democratic deficit on this question. To start with, Northern Ireland clearly voted to remain in the European Union, and that was ignored by many policymakers. More importantly, the withdrawal agreement and the protocol were processed through the Westminster Parliament. They enacted this legislation. It wasn't enacted by the European Union. And in the course of its enactment, it had the support of the governing majority at Westminster, and Northern Ireland has MPs inside Westminster. And this situation arose because of the support of one faction in Northern Ireland, the Democratic Unionist Party, for Boris Johnson's harder exit policy and their refusal to go along with Theresa May's soft exit policies. So if you can't have it both ways, you can't say that Westminster should be sovereign over Northern Ireland as unionists do, and yet say they should have a veto on everything that applies to Northern Ireland itself. They only have a veto inside those devolved arrangements that exist in Northern Ireland. That hasn't been affected. But there is no special democratic deficit that I can identify. And indeed, I use the term novel because giving Northern Ireland consent over functions that were not historically devolved is a reasonable concession to the rights and interests of Northern Ireland. What Northern Ireland doesn't have is MEPs any longer representing the Northern Ireland's interests in the EU, but it still has members of Parliament in Westminster, so it's only represented indirectly on one side of the joint committee. Yeah, I agree. There is no democratic deficit. That's an imaginative construction of the DUP.
Thank you very much for that. So I'm just keeping an eye on the time here, and I know that Federico wants to say a few words in wrap up. So I think that I'll just say thank you very much again to our three speakers. Apologies for the urgency on the timekeeping, and it's very difficult, I know, to squeeze such thoughts into 15 minutes. So thank you very much for that, and for your responses to the questions. Apologies if I didn't get to all of the questions or comments, but I think we've covered most of them. So thanks again, and I will hand back to Federico to say some final words.
Thanks very much. It was a pleasure to join you.
Thank you.